Okay, so today we're going to be discussing the preparation for the legalization of marijuana from an employment law perspective. So we're going to try and cover a variety of topics, including medical marijuana use, the duty to accommodate, the importance of reviewing and updating drug and alcohol policies, and what a good policy should look like, as well as drug testing. So I'll just go through a brief background on marijuana and the legalization of marijuana before we jump into those other topics. So in 2016, the World Health Organization identified cannabis as globally the most commonly used psychoactive substance under international control. And in 2013, an estimated 181.8 million people aged 15 to 64 use cannabis for non-medical purposes globally. So while approximately 20 countries have decriminalized cannabis, jurisdictions that have formally legalized cannabis for recreational purposes are the country of Uruguay, and within the United States, it's the jurisdictions of Colorado, Alaska, Oregon, Washington, Maine, Nevada, Massachusetts, California, and the District of Columbia as of January of 2018. Okay, so with respect to the legalization of medical marijuana, the Ontario case of Regina versus Parker in 2000 held that Canadians with a medical need have the constitutional right to possess marijuana for use in a medical context. Therefore, since approximately 2001, medical marijuana use has been legal in Canada. So the main thing that the Cannabis Act, which is coming into force that we're talking about today, will change is with respect to legal recreational use of marijuana. With this change, employers will now have to consider and address implications of legal recreational use of marijuana in the workplace. These new changes and considerations will come into force through the Cannabis Act on October 17th, 2018. The Act will address the legal access to cannabis and control, as well as regulation of its production, distribution, and sale. Importantly, the Cannabis Act is silent on a number of things. Specifically, the Act has no specific recommendations on workplace use and testing. There is also nothing in the Act that restricts how employers respond to marijuana in the workplace, so long as they're accommodating for addiction and medical use. This means that employers can still set rules for use of recreational marijuana at work in much the same way that they have rules set for alcohol now in the workplace. And these workplace rules regarding recreational use can still be enforced through the application of progressive discipline policies, much again the same way as alcohol is being addressed. So that's issuing warnings, documentation in writing, that kind of thing. Also, the Act allows employers to prohibit the use of marijuana at work or during work hours, and may also prohibit employees from attending at work while impaired, subject to human rights considerations, such as if there's a disability for which medical marijuana has been prescribed. So while the Cannabis Act brings changes to recreational use marijuana, it's still important to discuss an employer's responsibility with respect to medical marijuana. This is because the Human Rights Code strictly prohibits employers from discriminating against employees with physical and mental disabilities. Therefore, employers have a duty to accommodate disabled employees, including disabled employees who use medical marijuana to treat their disability. So this quote here says, where an employee can demonstrate a disability and an improved treatment plan from a physician for using medical marijuana, the regular principles around the employer's duty to accommodate apply, and the response of the employer will vary depending on whether the employee is in a safety-sensitive position. And we'll talk a bit more about that in a moment. So when an employee has a prescription from a physician for medical marijuana, this is not a free-for-all that permits the employee to do whatever they want. The prescription from the doctor for the medical marijuana does not entitle an employee to be impaired at work. It does not entitle an employee to compromise his or her safety or the safety of others at work. It doesn't entitle an employee to smoke in the workplace, as smoke-free laws apply to the smoking of marijuana in the same way that they do regular cigarettes. And it also doesn't entitle an employee to unexcused absences or late arrivals. However, importantly, the employer is required to attempt to find suitable workplace accommodations for disabled employees who have a prescription for medical marijuana use, just as they would be required to do so for any other disabled employee with a medical drug prescription. Okay, so before we get into the employer's duty to accommodate, there are a few duties that are on the employer with the prescription for medical marijuana use that on the employee with the prescription that they must do in order to actually trigger that duty to accommodate. So first, an employee alleging marijuana use connected to a disability will need to disclose to their employer the nature of the disability and the requirement for use of medical marijuana in connection with their treatment plan for the disability. And that connection is really important. Secondly, that marijuana prescription must be from a legitimate medical physician. So a naturopath on the payroll of your local dispensary is probably not going to cut it. It also needs to be clear that the marijuana prescription is for the treatment of that specific disability. Again, that connection is what's important. And thirdly, accommodation is a mutual process. It's not going to be solely the responsibility of the employer. The employee also has to work with the employer and be open to accommodation. And once there's been disclosure by the employee, whether it's disclosure that the employee is taking marijuana for medical reasons or they have dependency on marijuana, the duty to accommodate is triggered. Also, if an employer observes impairment at work, a duty to inquire about a need for accommodation of a disability is also triggered. This is because an employer has a duty to accommodate if they ought reasonably to be aware of a disability. So these inquiries need to be made. So what is accommodation? Accommodation is a duty that requires employers to take all reasonable measures to provide accommodation to a disabled employee without themselves incurring undue hardship. It's not enough for the employer to simply state that the employee cannot be accommodated without undue hardship. Actual efforts have to be taken by the employer to show that reasonable measures aside from termination have been made. And the employer must be able to prove that these steps actually occurred. So this makes it quite a high standard for employers, and if the employers do not abide by this, they can open themselves up to human rights complaints by employees who feel that they've been discriminated on the basis of a disability. Okay, and on the last slide, I briefly mentioned this concept of undue hardship and accommodating to the point of undue hardship, which I'll elaborate on a bit more as it relates to an exemption to the duty to accommodate. So basically, the Human Rights Code prevents employers from discriminating employees based on a number of predetermined grounds, which includes both physical and mental disability. However, the Human Rights Code permits an employer to discriminate on the basis of disability if the basis for discrimination concerns what's called a bona fide occupational requirement. So what is a bona fide occupational requirement? So this is a standard, say for example, a zero tolerance policy for alcohol in the workplace, and for example, applying to a heavy duty equipment operator position. So basically, this policy about the zero tolerance is adopted for safety reasons in that context. And the employer has to honestly believe that the policy is necessary in order for the employee to safely perform all job-related tasks. If the employer can prove that it's impossible for them to accommodate an employee or an employee with a disability without incurring undue hardship, then that employee does not need to accommodate the employee's disability. So what is undue hardship? So the courts have considered a number of factors in deciding whether there is in fact undue hardship, and they're able to meet this essentially an exemption. So these include the financial cost of the accommodation. So for example, the cost is so substantial that the accommodation would alter the essential nature of the enterprise. This includes the change to the structure or organization of work. So for example, it would change the change would be so significant that the change would substantially affect the organization's viability. And also the resulting risk to health or safety, which is a big one. And like we said in the example of a heavy duty machine operator or something like that, the risk is so significant that a change would risk the safe work environment in the industry to that employee, to those around them, their employer. And this consideration often arises in these jobs where safety is a huge concern and there's heavy duty equipment. And lastly, the size of the workplace. So is it even possible to accommodate when given the current size of the workplace? So this test for this exemption can be difficult to meet in many circumstances given the various creative ways there are to accommodate an employee. And lastly, on the issue of medical marijuana and the duty to accommodate, this slide provides a brief summary of some of the key takeaways from recent human rights tribunal decisions regarding medical marijuana and the duty to accommodate, which we've already touched on. So employees have to have authorized possession for medical marijuana, so this has to come from a physician, and they must make their employer aware of the requirement and the use of the medical marijuana for treatment of that disability. Once the employer has been made aware of this and the need for medical marijuana, the employer must make meaningful inquiries into whether the employee's use of marijuana was related to the disability and whether an accommodation was appropriate or possible. The employer must then take all reasonable and practical steps to accommodate the employee without undue hardship. Once the new legislative changes in October 2018 are in place, we will inevitably see the courts addressing the issues around recreational marijuana in the workplace, which is going to give us more guidance. At this point, most of the case law with respect to the Human Rights Tribunal is in regards to medical marijuana and the duty to accommodate. So I'll now pass it over to Jordan to discuss employment policies in light of the legislation or legalization of marijuana.
Okay, so yeah, I'm just going to touch on the practical implementation of policies, and in my work I tend to focus on contract drafting, employment contracts and policies and things like that. So even though we don't have a lot of tribunal or court decisions yet, we still have the reality of legalization, and there probably won't be a lot of case law for quite some time. So in the meantime, how do we put in place policies that are workable? So many existing policies deal with alcohol use already, but the main distinction is that we have medical uses for marijuana, whereas there's not prescriptions for alcohol. So there's a bit more complexity there, and it's not enough just to extend your current no alcohol policy to marijuana without dealing with some of the distinctions there. So right now the law permits businesses to ban the use of alcohol or showing up under the influence of alcohol during work hours. And a similar policy could be put in place for recreational marijuana. There's no real distinction. It's just with respect to the medical side of things that the policy will have to make a distinction. And Brittany mentioned as well safety-sensitive workplaces. So the nature of the business will affect your policy, and there's no real one-size-fits-all policy that can be put in place. But for safety-sensitive workplaces, we're often seeing a complete ban of alcohol use in the workplace, which could be extended to recreational marijuana as well. So I just put some quotes from a recent Financial Post article, and there's been a ton of articles recently, and this is just from last month, but a lot of commentary on what people should do without a lot of precedence or guidance to go by. This article refers to a quote from a senior technical specialist with the Canadian Centre for Occupational Health and Safety, and that organization tends to be the one that's really issuing the most guidance, or they actually did produce a white paper, they called it, that provided a bit of guidance there. So they are looking at that issue, and the conclusion of this article is basically that you've got to use your common sense judgment, and there's going to be no bright line test. And with cannabis impairment, that can be more difficult than alcohol, in the sense that you're not, if your current policy refers to a definition of impairment that covers alcohol related stuff only, like slurring speech, tipsiness, that sort of stuff, it's probably not going to be able to be extended directly to cannabis use. So the conclusion of that article was kind of positive in the sense that they're saying not much is, in the grand scheme of things, changing, and that you're still looking at impairment regardless of the source of impairment, and adapting your policies just to bring in one more potential source that will be legal. So moving on in terms of what a policy should actually have in it, and I've just kind of included a list of things from the Canadian Centre for Occupational Health and Safety. they did provide sort of a guideline. This was from 2017 about stuff that we probably would want to see in a policy. And one point that's been made in a few different articles I've come across is that the more you can focus on impairment in general rather than trying to get into too much detail about the source of impairment or the specific criteria, it's going to be a more flexible policy that will be perhaps more workable. So one of the items you want to include is the statement of the purpose and objectives of the program, so explaining to the employees why it's being implemented. A definition of substance use can be important, how we define that, and typically probably the broader the better there without trying to be too narrow. The definition of what the employer considers to be impairment. So again, would typically have sort of a general, anything that affects your ability to perform your work definition, but then you can also include a more specific list of things. And part of this is because it's a policy manual for employees, there's an educational aspect to it as well, and that you're trying to kind of make it clear what your standards are for workplace impairment, and then that ties into the fact that you're training employees to recognize, training managers to recognize and respond to impairment. Switch slides here. Brittany mentioned this briefly already, but if impairment is observed, there's a duty to inquire potentially on the employer as well. So if the policy has a good specific definition of impairment, it makes it easier for your employees to report, your managing staff to report impairment, and for you to deal with it as well. So there's just a quote from the Canadian Human Rights Commission there that talks about how if you do observe impairment, it's not enough to kind of turn a blind eye or not inquire further. There's actually a positive duty to inquire to see whether there is an addiction, if there's a disability that's underlying it, and how that can be addressed. So just to move back to other items to include in a policy, we've got a statement of who is covered by the policy and program. So making it clear again, the broader the better for this sort of thing usually, where it's employees, managers, everyone that might be working within the organization. We've got a statement of the employee's rights to confidentiality and a mechanism to confidentially report addiction or medical issues. So creating a written policy that makes it comfortable for employees to report and give you the information you need as an employer to actually meet your obligations under the legislation. And then continuing on down the list, a statement in the policy regarding if either medical, therapeutic, or non-medical substances are allowed on the premises, or under what situations they would be allowed. So this is one thing that's changing a little bit with legalization, is often employee policy manuals will say, any illegal substance not permitted on the premises. Often policies won't address alcohol, or they won't say, you can't bring alcohol onto the premises. Some do, but not all. So now, including an express statement, if you want to say that, legal amounts of recreational marijuana can't be on the business premises, you're allowed to say that in your policy, but it is something that you'd want to confirm if that's going to be the policy. In the same way you can ban alcohol on company premises now. Another component there is where it's recommended that an individual use cannabis for therapeutic purposes. Considerations may be needed to be given regarding how the product is consumed. So is there a plan for if someone has a medical prescription, how is it being consumed? And Brittany mentioned as well, smoking laws. The Cannabis Act actually amended the secondhand smoking legislation to plug cannabis into every tobacco reference as well. So it does carry through to that as well. The policy should confirm that arrangements have been made for employee education. So under WorkSafe regulations, there is a positive obligation to educate employees about the law and impairment. And the next point is basically just confirming that arrangements have been made for that sort of education that reinforces the policy. And then including provisions as well for assisting those with disability due to substance dependence, whether that's reporting the disability or some sort of mechanism that addresses that. And then that's tied in as well with accommodation that Brittany talked about. We're dealing with accommodation right in the policy if possible, or even having a separate accommodation policy is another way to go there, just so it's clear to managers and others that, you know, there's got to be a mechanism that recognizes that accommodation is necessary. And I've just included a list of things there that the Human Rights Commission has recommended. If there is a specific employee that needs accommodation and there's a plan for that, just how to go about doing that. So putting in writing, having that signed by all parties, and identifying based on the actual medical information and the specific medical situation, how that's going to be carried out. And then just some examples of what practically accommodation might look like. So we could have modification to the employee's schedule, accommodating treatment, appointments, hours of work, the work environment, setting out expectations regarding conduct and behavior within the accommodation plan, possible reassignment of duties if the employee is in a safety sensitive position, and then short or long-term leave is another example of accommodation there. So going back to just general points for the policy manual, if applicable, including statements of under what circumstances substance testing will be conducted, as well as the criteria for testing and interpretation of test results. And this is where this is a pretty difficult spot right now. There's not really a consensus in Canada on workplace testing. It's controversial. There's a lot of union disputes that relate to this, depending on what a collective agreement says. The unions are resistant and employees are resistant to testing in certain circumstances. But basically, if there is going to be something like that, it definitely needs to be as clear as possible, even though we don't have a real clear standard. And I think the BC Chamber of Commerce actually has a policy where they're recommending that there be a federal standard for impairment, and it's something that crops up throughout a lot of the commentary is the difficulty in assessing impairment, what actually qualifies as impairment. So I'll come back to that in a second. And then usually a policy will deal with a hierarchy of disciplinary actions too. So a warning system, if there's, you know, what's going to be the procedure if there is a violation of the policy. Usually a general statement of, you know, there'll be a warning and actions can be, you know, can lead up to termination. It's not necessarily saying, you know, you'll automatically be fired, because we have to deal with, you know, accommodation, we have to deal with progressive warnings and that sort of thing as well. So the reason, you know, why would we go to the trouble of updating our policies and making sure it's clear? There are responsibilities on employers to actively monitor employee and workplace safety. The criminal code has provisions that require employers to take reasonable steps to prevent bodily harm to workers and others in the workplace, and a policy can be part of that, showing that you've put the effort into training or educating your employees and managers, and you've thought through that process. So just one example, in a somewhat recent case, there was 4 construction workers killed in Toronto, and there was actually a criminal negligence causing death fine levied by the courts, and the site supervisor, I suppose, is defined as a senior officer under the criminal code. So he was one of the people that passed away, but he was found to be under the influence of cannabis, as well as a few of the other people that were on the swing stage. So the court ultimately found that there wasn't, because the actual supervisor was impaired, there wasn't, basically did qualify for criminal negligence. So having sort of a policy can help to address some of that risk. And then there's also work safe regulations. So this does go both ways in that it imposes an obligation on the employee and the employer. So in 4.20 sub 1, a person must not enter or remain at any workplace while the person's ability to work is affected by alcohol or drug or other substance. So there's a responsibility on the employee, but then also the employer must not knowingly permit a person to remain under the influence of alcohol or a drug, so that they're a danger to themselves or anyone else. So I briefly mentioned drug testing. Is that a practical solution now? For most businesses, probably not. So right now the courts have kind of said that there's a risk of it being found to be discriminatory on the basis of disability and perceived disability under human rights legislation. So the Canadian Human Rights Commission has issued a couple statements recently on this. So it's basically indicating it's a complex issue. There's a lot of items at play there, and the difficulty is even a positive drug test isn't going to necessarily prove that someone is impaired in that moment and constitute definitive evidence that justifies a termination or something like that. So even if you do the testing, you get a positive result, it's not necessarily going to solve the issue in itself. And the current law in Canada doesn't permit pre-employment or random drug testing. It has to be tied to a specific purpose. So whether it's a safety-sensitive workplace where that's and there's an incident or an accident, and then the testing takes place after that, some sort of concrete rationale is usually required for that. It's a little bit different, or can be different in a union environment, because often collective agreements will specifically address how that's to happen. But beyond that, it's a little bit uncertain. So in place of drug testing, or as an alternative, the consensus seems to be that we're kind of stuck with, and we don't even have a great definition of what is impairment from the courts yet in a workplace context, but we're kind of going back to the general definition of impairment, and especially in a safety-sensitive environment. So if you're not able to perform your work in a safe manner and you can cause harm or significant damage to yourself or others, that's sort of the standard. And Health Canada, the Canadian Centre for Occupational Health and Safety, did refer to this Health Canada quote in their sort of white paper that talked about the effects of cannabis, how it can affect motor skills and other issues. So it's kind of assessing, and without the benefit of a clear blood alcohol test. And I guess that's commonly identified as one of the issues, is that with THC testing, you can have, especially in chronic users, you can have a level of THC that shows up on a test result that would be problematic in someone that's not a chronic user. But for a chronic user, the testing, the levels may be built up over time, so that the test indicates, well, maybe there was something that was smoked a week ago, but it's because of the chronic use, it's built up to a certain test reading. Whereas with blood alcohol level, that's pretty much it's a pretty good indicator of where you're at right now, as opposed to historical usage. So for someone that's not a chronic user, a THC reading may be a significant problem where it's not for someone else. So that's where I think the courts are kind of reluctant to take or to impose a specific standard, and it's tough to come up with one. So just kind of summarizing on the practical policy implementation stuff, this is a list of suggestions from an article that was recently written by two employment lawyers. I thought it did a good job of summarizing sort of where we're at and what we can do practically now. So the first one, having a policy that addresses workplace impairment for all prescription, over-the-counter, and illegal and legal drugs. So you're covering what is impairment, no matter where it's coming from. Ensure the policy is effectively implemented by providing training to employees and supervisors. Ensure employees are aware of the consequences for failing to comply. Accommodating where there is legitimate underlying disability, and providing training to supervisors and allowing them to have the knowledge to identify impairment in an employee and provide tools for reporting that. And their conclusion in this article was, if we focus on the impairment and the hazard that the impairment represents, we don't need to be overly concerned with the source of the impairment. You still have the same rights you currently do as an employer to address impairment in the workplace, whether it's coming from cannabis or another substance. So just moving on to some kind of open-ended questions. I guess we'll have a question period if anyone does have any questions, but these were some of the issues that came up as we look through some of the articles, and might be kind of a launching point for some questions that you may have. But one difficulty is, how do we define drug in a policy? Does marijuana need to be separated out to account for medical use and accommodation? And yes, we need to find a way to do that in some manner. How do you define workplace? So is this policy applying just to, within the office? What if your company, sponsors an event and has some people there? The policy can apply to that, but you have to be pretty specific to make that clear. Are there going to be exceptions for recreational use permitted for breaks or lunch hours, client functions? Is there going to be any scenario where recreational use is permitted? Do we have adequate accommodation provisions to help employees with addiction issues or with the medical use of marijuana tied to disability? So in conclusion, I guess the law in itself is not changing in October, but there's, I guess, one more potential source of confusion, and the main issue, I think, is the analysis of impairment and how do we determine that without specific guidelines from the government. And I guess that maybe goes to the BC Chamber of Commerce policy, where we're trying to look at getting something like that, but it's not easy for sure. So that's pretty much it for the presentation. Skip ahead then. Got our little disclaimer, and then if there are any questions or comments, be happy just to kind of generally discuss any issues. I think that's definitely a tricky issue. I know there was some request for the legislation to address that specifically, or to have some sort of trade agreement or something in place with the U.S. directly before it came into force. I don't know if you've seen anything specific, no. But I did see one article that was basically suggesting that should have been done perhaps in the federal legislation, or there should have been a treaty of some sort that was put in place for that. Because my understanding is even with Washington State having it legalized, the border is federal, and they don't care really if you're going into a state where it's legalized. So my understanding is there's no sort of accommodation provisions in place currently, so it could be a significant issue where you've got an employee that, if you disclose you're using recreational marijuana, you could be refused entry. Or if you're actually working in a business, a cannabis related business, that would obviously be an issue too, to actually move across the border. But yeah, I'm not aware of anything that's in place currently. Yeah, it's not a perfect system for sure. You can have, I guess, the most we can do in some ways is have in your policy that, this is your standard of impairment. You'll have to make the judgment call, and if you feel someone is not able to meet a certain level of performance, depending on what the job is, then you reserve the right to not allow them to do that, right? So it's tricky. And in terms of having policies signed, that's definitely a good approach. If you do have policies in place, it strengthens them significantly to have them actually attached to an employment agreement, or have them signed before the employee starts work. So, if you're hiring someone and you want them to sign an employment agreement, if you attach as a schedule basically all of your policies, it's much easier to enforce rather than just kind of giving them a copy later on, a few months into the job or something like that. It's clear that they read it and they signed it before they started. That can help a fair bit. I think that it helps for sure if you're challenged on a decision, if you can present to the tribunal or whatever a copy of the policy manual that says these are our standards for impairment. We're going to make a judgment call if we feel you're not safely able to perform your job, and the employee has signed off on that, and it's integrated into their agreement. It's going to be a lot easier, I think, than them kind of saying, well, I thought it was the same as my other job, or the standard was the same as my previous job or something. At least you have something in writing then. But yeah, did you have any thoughts on that, or?
No, I think because everything's still so new and we don't know what it's going to look like, the courts haven't had issues like that before them, and so until they do, we don't know the way that it's going to go, and it's kind of time will tell, unfortunately.
Only if it's relating to an accommodation issue, so a disability. If there's a medical prescription and plan in place, and the person is not able on that day to perform their work, then it might be something we're finding alternate work rather than sending them home. But if it's recreational use, it would be, I think, basically the same as alcohol. If someone shows up and you think they're a little bit too inebriated and you send them home, there's no need to accommodate that because it's not a medical or disability issue, unless there's an addiction issue. But that, hopefully that would be addressed in the policy and that it's disclosed ahead of time.